Okay. Good afternoon, everyone, and thank you all for joining us for today's month service presentation of mediation versus arbitration. My name is Nia Murray. I am Programs Coordinator with Neighborhood Recovery and Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Ms. Myra Hippolyte. Also, the Houston Bar Association, and our presenter on behalf of the Houston Bar Association, Mr. Raphael Boza, who's going to be presenting our information here today. But also included in the partnership is Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, Harris County Tax Assessors, and Harris County Appraisal District. And together we make up A Month of Service. And basically, for those that don't know, A Month of Service is a collaboration of these 8 different organizations that come together on a monthly basis to offer a variety of workshops relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are quite a few people in various neighborhoods throughout the city, throughout the county, that do not have access to information like what we present on a monthly basis, or even don't know where to go to get such information, or even to know what available resources there are that they can actually access as well. We used to do these workshops in the community on a monthly basis, and how we came up with the name A Month of Service. We would stay in a community for an entire month, offering various workshops, and then going to a different neighborhood and doing the exact same thing on a repeat. So, but of course, due to COVID, we've had to adjust and adapt, and then we wanted to continue to do what we needed to do, and that is to continue to service the same community and continue to provide this information and resources to folks. So we had to go virtual. The fact that we've been virtual now for the last couple of years has allowed us the opportunity to broaden the topics or the amount of workshops that we actually offer on a monthly basis, as well as allowed us the opportunity to reach even more people throughout the city, throughout the county, throughout the entire state, and even throughout the country. So so thank you guys for actually for joining us and for continuing to support A Month of Service, and we definitely invite you to come back for other monthly workshops that we offer to the community. But today we're going to be here today presenting information about mediation versus arbitration. Lots of folks don't even know what is mediation, what is arbitration, and are they the same? What's the difference? What's the advantages, the disadvantages? What do you need to do? What's going to work best in your particular situation, whether it's having a dispute with a neighbor, whether it's you know, something going on with your employer or a relative or what have you. What's going to work best for you? And Mr. Bowles is going to be presenting that information for us today. So without further ado, I'd like to go ahead and introduce our partner with the Department of Neighborhoods, and then we will move right on to introducing our speaker, and he can move right on into the presentation. So Ms. Myra.
Thanks, Ms. Nia, and welcome, Mr. Raphael Boza. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods under the direction of Division Manager Paul Green. On behalf of Mayor Sylvester Turner and Director Takasha Francis, we want to welcome you to the Month of Service partnership. This partnership is all about giving back free information to the Houston community. We want to make sure that whenever you're going through whatever stressor you are going through in your life, and I love how Nia says that we need this information every day, not just when you're going through a stressor, but whenever you're going through a stressor or whenever you need the information, know that you have a team of partners that are right here by your side to assist you with the information that you need to make the right decisions, and whatever decision that is. We're not going to tell you what you need to do. We're not going to tell you legally you have to do that. This is only for informational purposes. This is not legal advice. So this is all about just making sure that you have all the information in front of you, that you can think through the process calmly and can work out through whatever situation you need. Guys, you're not by yourself. You know, many times in our lives, we're going through this and that and that and this and this and that. And when something happens, we're going like, oh my God, I'm handling this all by myself. And like I like to tell Nia, like Myra's way, I freak out. So we don't want you to do Myra's way. We want you to calm down, think through the process, and say, what's step number 1, 2, 3, 4, 5, 6, whatever. And so also you have a team of partners that you can call, and in whatever situation you're going through, you can call us and we can see if we can find other partners or other organizations that can assist you. Thanks, everyone. You guys have a great day. Stay safe and have a blast. Thanks. Thank you, Mr. Bosa.
I did forget that disclaimer that this is for educational purposes only. This is the information that is being presented is not legal advice. However, we do encourage you to reach out to our legal service partners if you find yourself in need of any civil legal assistance or services. Also, we ask that if you'd like to be, please be as interactive as you would like. Type whatever questions that you have in the chat. Or if you're joining us on Facebook, please type them into the comments and we'll go over the questions at the end of the presentation. In addition to that, we want to try to protect your privacy as much as possible. So we ask that the questions that you do ask to be as general as you possibly can so that your personal detail information is not getting out there for everybody over the World Wide Web to actually get access to. This session is being recorded and we will be sending a link out to everyone that would like to go back to review or to share this presentation with other people that may find this information to be beneficial. So I just wanted to put that out there real quick, just so you know when you guys are asking the question.
Hey, Nia, and
Yes,
just to give you an example, my name is Myra Hippolyte and I live at 2256 Dover Street. And I am having a problem with my next door neighbor. Her name is so-and-so.
Right. Exactly.
Don't do that.
Exactly. Don't do that. So we want to keep you, protect you as much as we possibly can. So just keep them to be as general as we can have them. So without further ado, Mr. Bosa, go right ahead and introduce yourself and we will move right on into your presentation.
Thank you so much. Thank you so much. My name is Rafael Bosa, as it's been stated. I'm an attorney here in the city of Houston with the firm of Pillsbury, Winthrop, Shaw, and Pittman. And I have been involved with the city of Houston, with the city of Houston and the Houston Bar Association for several years. With the city of Houston specifically doing their minority arbitrations, and with the Houston Bar Association in several of their committees and sections. So I have about too long of experience with arbitration, about 20 years of experience in arbitration and mediation and other methods of conflict resolution and dispute resolution. And this is what we're going to be talking about today. The title of the presentation says mediation versus arbitration. And I don't like necessarily that division because those are complementary processes. As I will explain to you, those are things that you could use together. And if they work for you, you will only need to use one of them, which typically would be your mediation process. So let's start from there. The mediation process, as some of you may know, is a process of dispute resolution in which the parties involve a third party neutral. And this third party neutral, through a series of techniques for dispute resolution, including what is called caucuses and joint sessions, will try to have the parties come together and try to resolve their dispute themselves. So the mediator is a third party, but independent typically of the parties, who's not going to impose their will on the parties, but rather simply help the parties to resolve the dispute. That sounds very easy, but in reality is very difficult, very complicated to do, especially in disputes in which you have to maintain the relationship between the parties. So, for example, you have a dispute with your neighbor, as Myra mentioned. If you have a dispute with your neighbor, you're probably going to be living with this person next to your house for a long, long time, unless you move, which is not the ideal situation. But with the mediation process, what could happen is we could find a solution your dispute that would be beneficial for both parties and would preserve that neighborly relationship that you should have in order to live together for the long term. From a practical standpoint, how do you start a mediation? Initially, you have to agree. Just like with arbitration, both processes begin with an agreement of the parties to attend the process. You could be forced by a judge to go to mediation, but you will never be forced by a judge to go to arbitration. So both processes are based on the will of the parties, the intent of the parties to resolve their dispute in a manner in which their relationship is preserved. So to go to mediation, you have to agree, and the parties agree also to name a mediator if the parties are not being forced to go to mediation by a judge. So how do you agree when you are in a very, very bitter disagreement with your neighbor to go to mediation? It is obviously not easy, but typically you're going to have to make an effort to approach that neighbor or that situation you may have already, and the intent needs to be, or the way in which you present this opportunity to your neighbor needs to be, hey, we have this dispute. If we're going to live together in a neighborly way, we have to try to resolve it. And in order to do that, I think the easiest way and probably the best way in order to continue to be neighbors and friends is to go to mediation and try to find a solution to our problem. The other way would be, for example, if your HOA is the one that is having the dispute with you, you need to look into your bylaws, into the HOA bylaws, and make sure that there is not already built into the terms of the bylaws a mediation and possibly an arbitration process that you agree to when you buy the property in that subdivision. So if that is the case, then you already have a built-in agreement that you can use to force the HOA or take the HOA by the hand to the mediation process. Once you get to mediation, you need to appoint your mediator, which is typically another source of contention, or it could be another source of contention, because you have to find somebody who is neutral and who both parties are comfortable with, who has the experience in terms of the nature of your dispute. You don't want to bring in somebody who's a family mediator exclusively to try to resolve a construction dispute with your contractor when he didn't do what he said he was going to do in your house remodel, for example. So you need to have some sort of idea of who are you calling. How do you do that? Well, there are resources out there. The DRC is a good place to begin. The DRC is a dispute resolution center for the county, and it doesn't necessarily will resolve your dispute or will set up your mediation, but it could recommend some mediators that the parties could then agree to. The DRC normally takes cases that are sent to it from the courthouse. So it's already in litigation. The judge is already looking at a case and sees the opportunity to resolve this dispute amicably through a mediation process, and will send that case to the DRC to be mediated. So that is the first place to go look for a mediator. Then there are other sources. Obviously, Google is your friend here. Go to Google and look for mediators in Houston. You will receive a long list of mediators because there are several. and you will find mediators in all price ranges. So if you are going to hire somebody to help you resolve your dispute, do your research, make sure that that person is the person that is experienced and knowledgeable in what and the nature of your dispute, and make sure you agree with your neighbor or your contractor or your HOA in who are you going to hire for that purpose and how are the fees going to be paid. Typically it's 50-50, you know, and a mediator can cost just like any other professional. You can have somebody who is very reasonably priced or somebody who is really expensive, and you can make sure that you ask about the fees early on and how do they charge them, because the mediators can give you time, half a day, full day, couple of hours, whatever it is that you need to resolve the dispute or to try to resolve the dispute, and they're going to charge you based on that distribution of time. So that's how the mediators work. So once you get into the process itself, so you have agreed with your neighbor, your contractor, your HOA that you're going to mediate your dispute to preserve your relationship and try to resolve it, to resolve the misunderstanding or dispute. At the same time, you have managed to agree on a mediator, and you have managed to find the right guy or gal for the right price. And then you are entering into the process. You have scheduled your session, and you're going to be seeing this mediator on a Tuesday afternoon. What do you do? Initially, the idea is to prepare yourself so you are able to tell the mediator what the basis of the dispute is and what are the facts of the dispute, what happened, and what do you want to get out of it. So you have to be prepared so you can guide this third-party mediator, neutral, to help you resolve that dispute. If you go unprepared and the mediator doesn't understand the nature of the dispute or doesn't understand how you want to resolve it or what do you want to get out of it, the process is simply not going to work as well, because the mediator will not have sufficient information to be able to help you in resolving the dispute with your neighbor or with your contractor. So initially, normally, the mediator will have you and your counterparty together in a single room in a joint session, in which you're going to air your grievances and say, hey, this is what I think went wrong, this is why I think it went wrong, and this is what needs to happen to make it better. And the mediator will listen to both parties and let both parties express themselves freely without interruption, and then typically will separate them to talk to each party individually and try to understand from an individual point of view what is happening. At that point, that is what is called the joint session at the beginning, and then the second part is the caucus. At that point, the mediator may consider going back and forth between the two rooms and try to build a little bit of relationship with the parties and try to build trust, not only for him as or her as a mediator, but also with that party and its counterparty. So the mediator may go to the homeowner's room and start discussing about what the contractor did that was wrong in the remodeling process, and then go to the contractor and ask a number of questions to understand what does the contractor think it did that was not wrong, or was wrong, depending. Normally, the mediator will not reveal to the other party what he has learned in those private sessions. The mediator then has to make a decision whether he's going to keep the parties separate or whether he's going to bring them together, whether he's going to try to start exchanging offers or not. Maybe there is a path to a solution saying moving a fence and a party will pay a part of it and the other party will pay the other part. The contractor will come back and finish the sheetrock and paint that it left undone, or will pay the homeowner a certain amount of money for the homeowner to do it with a different contractor. So things of that nature could be discussed, and the mediator, as I said, has to make a decision as to how to do it. Each mediator will be different. Each mediator will have its own techniques and its own ways of handling those kinds of situations, and it will be up to him or her to decide whether to bring them into a joint session to try to again make a bridge and try to find a solution that the parties will be happy with, or keep them separated and start exchanging offers until there is a middle ground reached and they can sign a mediated settlement agreement. So the mediated settlement agreement is a final result of a mediation. When there is a mediated settlement agreement, the mediator was successful in settling the dispute, and the parties can go home with an agreement and obligations to comply with. That agreement can be enforced and can be used in a court of law to claim the rights and duties that are contained in it. If the mediator fails to make the parties reach an agreement during the mediation session, the mediator has a few options. It can simply call an impasse and call it a day, go home. Each party goes to their own home and sees how are they going to continue with the dispute to the next level. Or the mediator can then propose a mediator settlement and send it to the parties and say, hey, I think you will reach an agreement under these terms. From what I have learned from your dispute, I think these are the best solutions that you can get, and you have, I don't know, 10 days to think about it and accept it. If the parties accept that additional effort from the mediator, then the parties can then settle the dispute and enter a settlement agreement as if it would have been signed during the session in the mediation. But if they don't, the impasse is maintained, the disagreement continues, and the dispute will escalate to a different level. The next level could be court, as you all know, or it could be an arbitration. And the arbitration, again, as I mentioned earlier, is a creature of contract. The parties must have agreed either before the dispute arises or after the dispute arises to send that particular dispute to an arbitration. Before the dispute arises, the parties can say, we have a construction agreement or a remodeling agreement. You're going to build a new bathroom and you have to put sheetrock tile, all the appliances and everything else that goes into a bathroom. And if a dispute arises, we'll go to mediation first and then to arbitration. If that is agreed in the contract, then all disputes related to that contract can be sent to arbitration. Then, if you have not agreed to that in the contract, you can still agree to an arbitration after the dispute has arisen. And you can say, hey, contractor, we have this dispute. We believe you didn't do the work correctly. There is incomplete work, or whatever the nature of the dispute is. let's agree to an arbitration to resolve this quickly and not have to go to court. The benefit is, of course, that you can keep your dispute private. And it doesn't necessarily mean confidential, because there's a number of reasons that maybe exceed this presentation, by which the confidentiality of an arbitration proceeding may be non-existent. But in principle, you can keep your dispute private. And this is useful for even for family matters. You can send family matters to arbitration, avoiding sending them to court and avoiding the public record. So if you have a dispute, a divorce dispute, for example, you can send the divorce dispute to an arbitration. And to the extent that you reach, you are satisfied with the decision of the arbitrator and you don't take the award to court to challenge it, the process will remain private, and the parties could keep their personal matters, the family matters, relatively private. So that's how you start the process of an arbitration. You have to have an agreement to arbitrate. And what does that agreement contain? There are a number of resources to find arbitration agreements. Normally they're called arbitration clauses because they are contained in other contracts. And as I say, it's contained because it's a separate agreement within the agreement. So the arbitration agreement is considered a separate agreement from your construction contract. It's considered a separate agreement from your HOA bylaws. So if for any reason the construction contract is considered to be null and void, your arbitration agreement doesn't have to be null and void with the generality of the other parts of the contract. So that's a nice feature of arbitration when you include it in the original contract. And obviously, if you agree to it after the fact, is going to be a separate agreement to take the dispute under the contract to arbitration. From that perspective, as I was saying, you can take to arbitration almost any kind of dispute. You can take to arbitration a dispute between an attorney and a client. You can take to arbitration a dispute between a contractor and an owner. You can take to arbitration a dispute between a wife and a husband in a divorce proceeding. You can take to arbitration a dispute about your survey, your property line. Where is it located exactly? And you can even take to arbitration disputes with the government, such as the protest of your property taxes, which Myra mentioned earlier to me while we were preparing for this, and I thought it was important for me to tell you. When you protest your taxes, you have and the decision of the tax authorities is to keep the taxes at the level that they were assessed initially. You can then request for an arbitration and go to a hearing with evidence of why would that decision, or why should that decision have been different. All right, so that's how you get to the process. Now, how does the process work? Very similar to mediation and what I described earlier. You're going to have to decide who are your arbitrators. You own the process. When you are in an arbitration, you own the process. The process of arbitration is a process in which the parties decide what happens. And even if the parties rely on third-party rules, for example, the typical is the American Arbitration Association, very well-known rules that are used generally even for arbitrations that are not managed or administered by the AAA. So even if you have those rules, you are going to be in control of the process. typically by agreement. Everything is done by agreement. So if you decide that you're going to have a hearing in Vietnamese language, you can do that, and you can find arbitrators who speak Vietnamese who are going to be able to hear your case and make a decision. So, as mentioned, the initial stages of the process are very similar. You're going to have to decide who your arbitrators are going to be. There are several ways of doing this. A typical way, let's say, is one party appoints one arbitrator, the other party appoints the other arbitrator, and the two appoint a third, who is typically the president or the chair of the tribunal. Interestingly, when you have only one arbitrator, which you could have only one person deciding, as if he was a judge or she was a judge in a court of law. You could agree to who is going to be that person, or you could even say, you know, I want Myra or Naya to appoint a third party who is going to be the sole person who decides my case. So you designate a third party to appoint your arbitrator. You lose a little bit of control of the process if you do that, but you rely on somebody knowledgeable who's going to appoint somebody to decide your case. And then you could even go to a judge and say, Judge, my neighbor and I have this dispute about our fence and our property line. We have decided to take this to arbitration, but we want you to appoint the arbitrator to keep it neutral and to keep it impartial and to keep it out of our hands, so that when the decision is issued, we cannot say, oh, my neighbor rigged the process or somebody rigged the process. So you have all those options. You can appoint them yourself, appoint one person or three people. You can designate a third party to appoint your arbitrators, or you can go to the judge and appoint and request for an appointment. Once that has been done, once your tribunal is constituted by one or three people, normally, those people have full control of the process now. So they can make decisions, procedural decisions, and how is the process going to be conducted without having to ask the parties. And at that point, the process starts moving at the pace the tribunal gives to the process. So the tribunal is going to determine whether the parties have urgency to finish or not, and then, you know, they're going to talk and be in constant contact with the parties to determine how is the process going to be conducted in order to hear the case and issue a decision. I think it's important to mention that parties should never communicate with the arbitrators separate from the other. So you have party A, the owner, party B, the contractor. You don't want the owner communicating to the arbitration tribunal without the contractor's knowledge. And you always want to copy your other party in all communications with your tribunal. Another interesting feature is you can be represented or you cannot. You can be represented by counsel, or you can go pro se, which is without an attorney. And both options have their pros and their cons. Obviously, if the dispute is somewhat complicated and based, for example, in a contract, which may be sometimes confusing and difficult to read, it may be beneficial for you to hire an attorney to represent you in the arbitral proceeding, as this proceeding, unlike the mediation, will have a final binding decision issued by the arbitrators. So in this case, unlike in mediation, the arbitrators will impose their will and their opinion on the parties and will resolve the case with or without the parties, um, with or without the parties' approval. So the parties may not have reached an agreement as to how are they going to resolve their dispute, but the arbitral tribunal, just like a judge, will decide the case finally, because typically there is no appeal unless you agree to it. So we have made our agreement and have decided to go to arbitration. We have appointed our tribunal and are moving forward with our process, and we get to the hearing. What happens at the hearing? So the parties present their evidence. You as an owner, for example, again, the owner and contractor example, you as an owner are going to show your contract, your pictures, your invoices, and everything you have related to that construction project for the contractor to revise and for a tribunal to evaluate. The contractor will do the same, will present the contract, will present checks that you have given them, will present all their invoices from the material that they purchased, etc. And they're going to make the case that they don't owe you anything, that they completed the work, and that you are making an unfounded claim. And you're going to have to make the claim that they in fact owe you, they in fact didn't complete the work. And the tribunal, based on the evidence that you present, is going to decide ultimately what is the truth of the case. Who did what that was incorrect, and who owes money to who. So that decision is called an award, and it's done at the end of the hearing, typically a few weeks after you finish your hearing, or depending on how much time you have given the tribunal to do the award. Some awards may be issued, within hours of a hearing finished. Some could take months and could require post-hearing briefing on the law or on the facts. That all will depend on what was decided during the proceeding. But the award is technically a final decision that can be enforced in any court of law, and the monies, if awarded, can be collected from the other party. The award the law actually protects arbitration awards with a special care, and it only has very limited possibilities to overturn it. You have to show, for example, that the arbitrator was corrupt and took money from your neighbor or your contractor, and you have to provide evidence to that to be able to overturn an award. It's a very high burden and very difficult to do. So that's a good thing about arbitration. You get to a final decision that cannot be challenged, or it can be challenged, but it's hard to challenge. And it's very enforceable in the 50 states without a very complicated proceeding. So that's why I said initially that I did not think that this presentation should be mediation versus arbitration as if they were in conflict, but rather mediation and arbitration as two processes that work together to help you resolve a dispute. Now, obviously, as I mentioned earlier, mediation has the strength that it preserves relationship and it can build consensus between the parties, so that when the dispute is resolved, both parties are satisfied, or both parties are dissatisfied with the result. On the other hand, arbitration has the similarities with the court, that the parties are not going to be in control of the decision. There will be a third party looking at the evidence and deciding the case. And that doesn't necessarily preserve relationships, because one party will be satisfied and the other one will be dissatisfied. And because you cannot challenge an arbitration award with ease, as you can a court ruling or a judgment, then the relationship really becomes difficult to repair. From my point of view, these processes need to always be used together, or if possible. And as a neighborhood building tool, mediation is much stronger than arbitration. But arbitration provides finality, which is also very good to try to move on and move past disputes that the parties may have. And with that, I think we can go to Q&A if Naya and Myra are okay with that.
I don't believe there are any questions that are in the chat just yet. Let me double check.
I think you mentioned you had some pre.
I have some questions.
Oh, Will Jr. has a question.
Oh, go ahead. Will.
Hi, how are you guys?
Good.
Great. I just wanted to ask, what are some of the qualifications to be an arbitrator? Good question.
Qualifications vary. I mean, you can run the gamut from the parties providing in their contract exactly what they want. So in the example of the Vietnamese arbitration that I mentioned, the parties could have decided that it needs to be an attorney licensed in Texas who speaks English and Vietnamese fluently and who has more than 10 years of experience, right, as an attorney. That could be one option. The other option could be simply the parties are engaged in the construction business, and it is, for example, two contractors or an owner and a contractor, as I have used this example repeatedly, and that those parties decide that they want to have somebody who's knowledgeable in the construction industry, but doesn't have to have an attorney title or a degree. So they go and find another contractor, unrelated, from a different state, maybe from a different. So it's a neutral and impartial party, but still knowledgeable in the construction business, and they bring him in as an arbitrator to decide the case because he knows exactly how the construction industry works. So it could be, it's a variety. It depends on what the parties really want.
So is there like a yellow pages or something that you go to go find arbitrators and mediators, or like how do you find it? Where do you go?
Okay, so where do you go?
Yeah.
That is a good question because there is a number of resources out there where you can find arbitrators. As I mentioned, the AAA, and the AAA has a roster of arbitrators and a list of people who arbitrate cases. It's a little difficult to get to it sometimes because they use it for their internal purposes, but I think it is published. Other institutions do the same thing. And if you just Google construction arbitrators in Texas or in Houston or on a zip code, you could probably get a list of people who do this for a living, and will, or who are like me, who are like attorneys, experience on the topics that experience in arbitration, experience in construction, and that who could help you resolve the dispute.
Okay, so you just search for whatever area or topic or subject that the conflict is about, and then that. Okay.
Yes, the same that you would do for your mediations. As I mentioned, you can go to the DRC and try to find the mediator in the DRC that could do it. The DRC will, as I said, typically doesn't take cases from the street, but they take it from the courthouse. So they can give you a list of names, and they say, well, these 5 people could be ideal for you because they are in the $300 per day range, and they are knowledgeable in construction. Myra, you were trying to speak, but you were in mute.
You're still on mute, Myra.
God, Jesus, thank you so much. So they don't have to be certified to be an arbitrator or mediator or?
To be mediator, you have to be certified for the state of Texas, because you have to know the techniques of mediation.
Okay.
And mediators that have an initial certification can do commercial cases, and you have to get a subsequent certification if you want to do family law cases, because you have to understand family dynamics, a little bit of psychology, and other things that are related to the more sensitive family setting. You need to know, child care laws and child care and child custody laws, etc. So in order to become a family mediator, you do need to get certified in addition to an initial certification, and those are several hours. I believe the regular commercial certification is 40 hours, and the additional family is 10 hours. So you have to have a total of 50 hours of additional training in order to become a family mediator. And that's why mediators are not necessarily cheap, although they always volunteer their time. For example, the DRC is an unpaid office. So when a court sends in a Harris County, every county has a DRC, dispute resolution center, and the courts of that county send their disputes to the dispute resolution center to be mediated.
So for a mediator, you do have to be certified.
Yes.
Do you have to be an attorney or no, or is that no?
Nope. You can be an engineer, a psychologist, a sociologist, whatever. You can even have no profession. You can just have they don't even request a high school degree, I don't think.
Wow.
It's just your training and your interest in participating.
So then as an arbitrator, you don't have to be certified.
No.
So you could be both then, a mediator one time and arbitrator another.
Yes.
Okay.
It's not necessarily advisable, although I have seen cases in which it happens that the same person, first mediates the case and then arbitrates the case. I have seen that happens in family cases, but it's not necessarily the best situation, because to the mediator, you can tell a lot of confidential things that you don't necessarily want to tell the arbitrator when it's resolving your case.
So why is the arbitration is considered legally binding as opposed to the mediation not being? And then how does that work if you're coming to an agreement?
So mediation ends up in a contract, which is legally binding, but you have to go to a court and enforce it. And it's very easy to enforce a mediated settlement agreement, because the judge is going to look at the parties and say, well, you reached this agreement. Why are you not complying with it? And the other party is going to say, well, I didn't mean that. I didn't mean what it was in the agreement. I mean, they don't have a party who breaches a mediated settlement agreement doesn't have really good arguments. The only problem is you have to go to court and claim a breach of contract.
So there's additional legal steps.
So there's an additional step. It's not going to be very complicated. You're not going to need a lot of discovery, and you're going to be able to get a judgment against that agreement relatively quickly. However, it's not as fast as an arbitration, because the arbitration is basically the same as an unappealable judgment. So you get an order from the arbitration tribunal, and you can go directly to the courthouse and enforce it. Now, the other party is going to try to prevent you from doing that, but it will have very, very limited ability to do it. There's only a few very limited bases to do this.
Wow. So you can even go through a divorce,
Correct.
child custody, I mean, easily without having to go through all the rigmarole of.
Yes. So you're in a family mediation, you can reach a family mediated agreement in which you're going to have your custody details and you're going to have your possessory order, and everything is going to be listed there so that the parties can live by that agreement. And if they don't, a court can enforce it relatively easy.
What do you do if you find yourself in the middle of a mediation or arbitration and you feel as though the mediator or the arbitrator is actually taking sides?
If you feel that the mediator if you feel like your mediator is taking sides, there's not much you can do, because the mediator is not going to decide your case. It's you who is going to decide your case. And typically mediators will try to come into those caucus rooms that I mentioned, those separate rooms, and say, dude, your case is terrible. You did not finish the work. You did not finish the work. And they're going to take you to court or to arbitration, and they're going to mop the floor with you. So you better agree now to something that you can agree, rather than have somebody else impose it on you.
Mhm.
That's what they are. That's what the mediator is going to do, to try to convince the parties to move from their position of,
If they're a good mediator.
well, yeah, it could happen. Yes.
Thank you, Will.
Because
Then,
I have been in mediations and the mediator was just sitting there like, you guys hurry up.
Wow.
that's unfortunate, because that will gives the mediation a bad rap. And I agree with you that there's good mediators and bad mediators. And sometimes you get what you pay for. If you get a mediator for free, the mediator is going to want to try to settle the case as soon as possible to get out of there or get to the next case, because he has 4 cases in this morning. But if you pay a mediator $1,000 for half a day, that mediator is going to put the effort to try to get your dispute resolved. So
Do you go through the same process like with any other profession, where you check background and stuff like that for references for mediators and arbitrators?
yes, I mean, if you're doing your homework, you're doing that. You're Googling it, you're calling, and Will, for example, will never go to that mediator again.
Let me ask you something. If someone is protesting the price of their homes, let's just go through there. Because a lot of people are going through protest process right now. And they first go through the appraiser. You don't agree with them. Then you go through the board. You don't agree with them also. Then they say you're gonna go to arbitration. That's the next process, which they don't tell you that. They tell you that it's gonna be a judge, a county, and you all of a sudden everyone goes, ooh, I don't have that in. I gotta hire an attorney, but actually it's arbitration. So if you go through all that process and you go through arbitration, can you pick your own arbitrator, or would it be the county, or what's that process?
In the county level, it's different, because these are people that are in the roster of the county.
Mhm.
So the county has developed its own list of arbitrators, and it randomly appoints them for your case.
Okay.
So these are people that have knowledge on the appraisal process, and have knowledge of home appraisals in general, and property appraisals. So they look at your case from that point of view, professional point of view, and they do normally have good, I would say, good context of what are they deciding. I have gone through that process a couple times, and it's been successful, not for my house, but commercial property.
Mhm.
And I have seen how they decide. They look at the evidence. What is the condition of the property? What are the comps? Why is your property different than the comps? You have to make a case. You still have to present your evidence. You have to convince them that your property is different. For example, if your property is 3 feet lower than the rest of your neighborhood for whatever reason, not necessarily because it sunk, but it was naturally that way, and your property is 10 times more prone to flooding in a normal heavy rain than your neighbors, then there is a good argument that the comps are not necessarily applicable.
And we're going through about 90% of the homeowners right now are going through the protest process.
Yes.
And last year and because I am one of those believers in protests.
Me too.
That's just, and this is my personal, just talking about my reputable life. I did not realize, because it always terrified me when they said, well, they may make it higher and you're going to have to go to a judge. Well, then last year I finally found out that it's actually going to go through arbitration. If I would have known that, I would have gone all the way.
Yeah, I don't think they make it higher. They can only make it as high as a appraiser.
And I think that's so important for our community to understand.
Yep.
That you shouldn't be afraid of certain, like protesting the appraisal of your homes, especially if you're protesting and they're appraising your home like a neighborhood that has.
Especially neighborhoods which are in transition, which we have a lot of neighborhood in Houston. You have a house, that it's worth $2 million next to a house that is worth 400 or less, and the height is a perfect example. So
Right.
So you need to protest.
And so when you're going through an arbitrator, it would be just like you're doing with the 3 boards. You're just giving them the basic information, take your pictures, show your information, and show them that your neighborhood is nowhere compared to the neighborhood that they're using for your appraisal of your home. Because 9 times out of 10, they're using a neighborhood that's already developed, has a lot of things going for them, or it may not, but you should be able to use maybe the same information you're using with the board and not to be afraid with arbitration. Because you don't have to agree with that. Am I correct? Or does the arbitrator automatically decides and that's it?
Right.
Okay. All right. That's something new. Thank you so much, because now you got Myra.
I'm sorry. So does the arbitrator decide and that's it? I missed that. Did he say yes?
Yes, he did.
Yes, the arbitrators in the protest process will decide.
That's
Okay.
fine.
And so how is the arbitrator selected again?
If I remember correctly, I haven't done this in a little bit, but if I remember correctly, is the county has a list of arbitrators and they randomly appointed your case.
Okay.
So protest.
I need to see if I can get on that list. I'm a certified mediator, by the way.
Oh, thank you, Will. That's great information.
Yes, ma'am. And I work within our CDC, so I'm just developing
Will,
my.
We cannot advertise what we do. So this is for informational purposes only. So thank you so much, Will.
Okay.
Good try, though. I like it. I love it. Mr. Rocha, Nia, I know you have 1,000 questions and my brain is rolling, so I don't want to take over.
No, that was okay. I was kind of thinking of stuff as you were going when I was asking about generally, how do you determine what's best to do, go through mediation or arbitration? Like,
As I mentioned earlier, it's a consideration that you have to make based on the facts of the dispute. Do you want to make an effort to try to maintain the relationship with your neighbor or your contractor? Then possibly mediation would be the best option for you, because then you can actually try to build bridges and try to build consensus with your neighbor or contractor. If you just don't care and you want a final decision, maybe arbitration is the best way forward.
So let's just say a neighbor, their tree limbs are going over to the next door neighbor's property, which we get that all the time. And we
Yes.
say that's a civil concern, they need to work it out. Mediation would probably be one of the best situations, or if they can work it out.
If the tree branches are going over your fence and unless it's a very valuable tree for your neighbor, it typically is something that you knock on the door and say, hey man, I need to cut those limbs, do you mind? And no problem. But if they do mind, then you have that's a different situation, because you have a legal right to cut those without even asking for permission.
That's right.
But if it's more like the fence is a foot off and they just put a fence 3 years ago and you bought the house and you're finding out that this is off, then you just moved in, right? You're gonna be there for a while. So maybe a mediation is the best way to handle that dispute.
which cheaper?
What if there's a neighborhood that there's a property that has weeds, junk motor vehicles, dangerous buildings, and it seems like the property owner is not maintaining it. The city's gone out there and notified them, and they're in the process of doing something, but they haven't done yet, and you live next door to it. Could you ask a neighbor, take it to mediation, or should wait?
Well, it depends on, in that case, if the neighbor has the intent to comply, then maybe that's the best way to handle it. Just wait and offer assistance if possible. But the city is already on it. So really your interest in getting it done is already being addressed by an authority. So maybe not necessarily a best case scenario to go to a mediation or an arbitration.
So what if the city's issued a lot of citations, still nothing has been done with the junk motor vehicles still sitting there, or the dangerous buildings still there, and it's years after years after years? And I'm just talking about some of the things that a lot of the community talks about. Still call 311, still call the city, and then go to arbitration or mediation, or maybe not.
Well, if it's on your property, or if it's impacting your property in some kind of way.
Well, it's diminishing the value. It's diminishing the value of the
Oh.
property just in principle.
Oh,
But I find it hard to be able to make a claim against your neighbor.
yeah.
I mean, you could possibly, but it's a little difficult.
Absolutely.
Generally, it would be an eyesore for an actual buyer to come through and see it. It wouldn't
Right.
necessarily impact the value of the property because of the market in the area. So that really wouldn't.
Well, but if you have an issue of that nature, maybe first check HOA and see how is that addressed, and then second, maybe insist with the city, because that's really the
Doesn't
best way to handle it.
That's what I
Okay,
thought.
in that regards, if you do have an HOA and they do have, their bylaws and things are set up where you're not supposed to have junk motor vehicles, but they're not enforcing it. So then, and what recourse do you have with the HOA then at that point for not enforcing it?
You can make a claim against the HOA for not enforcing the bylaws. Mhm.
Mhm. Leave it alone. Mhm. That's where we left it. Mhm. We're not going farther than, mhm.
Okay.
That's informational purposes only. Mhm.
Indeed, indeed. And I'm not a real estate attorney, so
Yeah. Mhm.
so
We're
you
good.
need to consult with somebody who actually can tell you whether the terms of your bylaws support that.
Okay.
Mhm.
Gotcha.
Thank you so much. Next question.
I think that was all I had that was coming to mind throughout the presentation. So let me check
Oh my God.
Facebook here.
So let me ask you, so if you've gotten in a wreck and the insurance is they'll always go to arbitration or mediation, one or the others. No?
Depends on the terms of your policy. And typically they would, but not all of them.
Okay. All right. What if your insurance says, no, a hurricane, let's just say Hurricane Harvey came through and you're insured, but your insurance says, well, no, we're not going to cover that. So then you can take it to arbitration yourself or mediation.
Yes. However, I don't advise you to do it on your own. In those situations in which, for example, your roof was tore up and they don't want to cover it because, oh, it was too old already.
Yes.
Get an attorney.
And that's so important, everyone. And this is for informational purposes only. But when something like that happens and you have a dispute with your insurance, specifically some type of damage, we in our general mind will say, well, I can go to arbitration ourselves. First, in your mind, always think get an attorney first for something like that, because you're dealing with big pockets and you need to get someone that's going to take care of you. Thank you, sir. That was wonderful.
What's
Yes.
generally the cost, the most cost-effective way? I'm not gonna say the cheapest. What's the most cost-effective way to resolve conflict when it comes to mediation versus arbitration?
That's a hard question because it all depends on the nature of the dispute, what you're getting. I mean, if you're in a dispute with your contractor for $750, you really, for completing the bathroom remodel, you may not want to go to a mediator that charges $1,000 or so. It all depends. It's hard to say, but mediation is typically because it's 1 day or 2 days, it's typically cheaper than an arbitration in which you extend the process longer.
Okay.
Okay.
All
And
right.
is there, and I know like with most attorneys, of course, it ranges, but is there a range of what cost should be? So for those folks, if they're out there shopping around for a mediator or an arbitrator, if somebody's charging you an astronomical price, they don't, because most folks don't know what's the going rate or what's a good,
I don't know that
range.
there is a going rate, but
there isn't. Oh,
I think arbitrators who are attorneys charge anywhere between $500 to $700 for half a day for 4 hours.
mhm.
And there you go. From there you can go up, and that is a split between two parties. So one party, if you're talking about $600, is $300 per party.
And actually, if you have such a situation like that, it would be best going that way than hiring an attorney that you're still
It cost
negotiating
you
the
thousands
process.
of dollars.
Yeah,
Yeah.
I mean, if you feel comfortable enough to handle your dispute
Mhm.
personally in a mediation, why not?
Love that. Why not? Why not, Nia? I love that. If you feel that comfortable, why not?
Right.
I'm going to take that one.
All right. Well, we don't have any other questions. There aren't any questions in the comments here on Facebook either. I keep watching there to make sure that we don't have anything. And I don't see any other questions in the chat.
But you know what,
Um,
Nia, we're gonna get him back because you and I are gonna have our think tank going and
Of course, of course. It was like I told Myra this morning, it seems like whenever we get together to have lunch or breakfast, we're always coming up with an idea or more questions. So,
we
you know,
work
who knows?
off each other's thoughts.
That's good. That's good.
It is.
All right, well, good deal. Thank you very much, Mr. Boza. We
Great
definitely
job.
appreciate you coming in at the 12th hour.
It was a pleasure.
To present. A lot of folks don't know that, you know, all of our presenters that we have are volunteers. They do take a lot of time out of their day, 2-3 times a week coming in to give these presentations that we have. And we cannot do this without you guys and all of the partners in the month of service. So we definitely appreciate you guys and, you know, taking the time out of your day and, you know, to do this for us on a voluntary basis. So we appreciate it.
It's a pleasure. Thank you.
Okay. With that being said, guys, thank you very much for joining us this afternoon. We ask that you just take a couple of minutes following this presentation to complete our survey. It's just a few questions, but we are in the process of meeting to schedule for our fall session. So we would love to have your feedback to know if there are any workshops, presentations, or topics that we have not touched on yet that you guys may be interested in, then please let us know. In addition to that, we just like to hear from you. We want to know how we're doing. You know, was this helpful? Did you get the information that you thought you were going to get when you got here, and so on and so forth? So just let us know. So
Hey, Nia, they just cannot say Myra talks too much. Not working anymore. No, I'm joking.
she has cut back a lot. No, just kidding.
I have.
All right, what do we have coming up? Tomorrow we have maintaining and adding value to your home. And good thing that you were talking about, you know, HOAs are not, sorry, protesting property taxes or what have you. We're gonna have a licensed inspector, home inspection that's going to be on to kind of tell people about different maintenance tips and things that they can do to help with prolonging the longevity of their home, as well as when somebody's interested in putting their house up on the market or whatever they're looking to do, some renovations or what have you, what actually adds value or market value to your home for resale. I mean, a lot of people go in and they start fixing up and doing a lot of things thinking that, oh, when I go to sell my house, it's going to be that much more valuable, but it actually does not. So you might want to join us for that. Next Tuesday, we are having our disaster awareness presentation, as well as our property tax workshop and about exemptions and how they actually can save you money. So we definitely want you guys to join us for that, as well as our foreclosure workshop next week. We know that a lot of homeowners are still going through a lot of financial hardship. While there is still available, that the Texas Homeownership Fund still does have funds available for those folks that those homeowners that do need assistance with paying their mortgage or property taxes or homeowners insurance and so on, or HOA fees and things like that. So join us for that information. And then we have coffee and conversation at the end of the month. Myra, you want to tell them about coffee and conversation?
Yes. You know, a lot of times we try to call the city of Houston and they call 311 and they say, well, this department handles it. Call that department and you say, I have this concerns, and then that department, oh, well, wait a minute, we don't handle it. Transfer you to another department, and it becomes very impersonal. So what Coffee and Conversation is all about is meeting you personally. Right now we're doing virtually, but starting in August, quarterly, we're going to meet in person and have you speak with different department representatives. You tell us your concerns. We'll have the department representatives meet with you, document your concerns within 48 hours to get back with you. We also have new programs within the city of Houston that we want to make sure that everyone throughout the city of Houston is educated. Thank you, Mr.
I'm gonna need to
Bosa.
go. I'm so sorry to interrupt, but
That's okay.
I need to jump off. Thank you.
Okay, thank you.
It's been a pleasure. Take care. Bye-bye.
Thank you.
Bye-bye.
Bye-bye. So Coffee and Conversation is all about giving back. The City of Houston Department with the Houston community, and you're working together just like an arbitration or mediation. We're working together to solve your problems in person, one way or the other.
Good deal, good deal. All right, with that being said, thank you guys very much for joining us this afternoon. We yield you your time back. So have a wonderful remainder of your day. Take care of yourselves. We look forward to seeing you at our next month of service presentation. So you guys have a wonderful day and take care.
Thanks, everyone. Stay safe.
All right.